Pinaka, and very good morning to everybody that has joined us this morning. And we are today going to be conducting the second part of the webinar that we started yesterday. And yesterday was a very interesting session, two sessions actually that we did. With an economist joining us in the first session when we talked about the economic impacts of the, particularly on Fiji, and then later on we had a session. It was an information session essentially on COVID-19, the nature of the virus, the reproductive ratio, the vaccines and treatments that are in development, and other pertinent information relating to the COVID-19 virus and the pandemic that is currently sweeping the world. So we welcome you once again. Thank you very much, everybody, for being on time this morning and for your continued interest in the webinar. We hope that today is going to be a very fulfilling day for you. We do not anticipate to go over 1.5 hours today. So we look forward to your full participation. I think that is absolutely critical, that we do have dialogue happening. We have inputs from a diverse range of people so that we are able to have those critical conversations that are in fact lacking at this point in time, and there are very limited opportunities for engagements of this nature. So as you will know from the program that was circulated, that this session is going to look at constitutional rights during pandemics. So usually what happens when there are states of natural disasters, when there are health crises, then the government invokes certain emergency powers. And in most cases, this means that the certain liberties, rights and freedoms that are afforded normally in democracies during ordinary times are then temporarily suspended, and the state then has overriding powers to take a whole range of actions. And the Fijian law enforcement agencies, of course, have been quite strictly enforcing a lot of those laws, and the people, of course, have been subject to a lot of those. The reason why we need to have a discussion on that is because there is a lot of confusion amongst the people on what are some of those laws that are in application, or some of the regulations that are in application. What is the extent of those regulations? How do they apply? And then there, of course, have been different interpretations of certain laws by the respective magistrates and judges. And then there also have been the executive arm of government that has been making commentaries about judgments of decisions of magistrates and so forth. So a number of these are, of course, departures from what happens during normal times. This morning we are very fortunate to have a legal expert amongst us, Ms. Laurel Vorasi, who is also the president of the Fiji Law Society, the professional body for lawyers in the country, and she's going to take us through a presentation where she is going to talk about constitutional rights during state of natural disasters, and especially how they apply to the Fijian context. And then later on, we hope to have a very engaging conversation about what are reasonable limits, and given the peculiarities of our context, what sort of limits are desirable, what sort of limits are necessary to ensure that certain imperatives such as containment of viruses and diseases can be achieved without impinging too much on freedoms, rights, and liberties that are expected in democracy. So, thank you very much, Ms. Laurel Maurasi, for joining us this morning. And we thank you so much for your time. And we now invite you for your presentation on that you have prepared for us this morning.
Thank you very much, Nilesh. Yes, it is obviously a much needed discussion on the different rights and freedoms that the public have, as well as, with the COVID laws that are now in place, and how do we reconcile the two, given the various views that people have taken, some agreeing that, some promoting that they should be able to restrict certain rights and freedoms, and where do we, how do we discuss this? How do we look at it in the context of what laws are in place and reconcile it? So what I've done is just let me just share my screen so that you'll see. I've just put together some some slides for us. And oops, not sure. It's this one. Okay. So now, if we look at the laws that are already in place before even COVID came to pass, I mean, we'll see from history that this pandemic, or a pandemic, is not something new, in the sense that pandemics have been there from time immemorial, and different governments and different countries have had to pass legislation in their parliaments to ensure that the people, that their duties as government with respect to the protection of people and their rights and liberties are in place. And you'll see that in Fiji, the first thing we go to is the constitution of our nation, and the famous blue book that was distributed freely to many people. But ultimately, the constitution that we have in place is the supreme law of the land, and any law that is inconsistent with it is not valid. And you will see that this is ably covered. I'm hoping that everyone has a constitution with them, since we're going to discuss constitutions. But we'll see that because it's the supreme law of the land, it binds the judiciary, it binds the executive, it binds the legislative branches of government. And so it's so important for us to know that the government has a law in place that makes it mandatory for them to follow. So before we even go to the COVID laws, we look first at the Constitution being the supreme law. Now, you have Chapter 2, which is the Bill of Rights, and also there's discussions on the different freedoms that are available. And I've just put together some slides on that. But before we go there, one of the things that people are always wanting to know is, what's the difference between rights and freedoms? And you will see that I've been able to put a definition on it. It is, and you'll see from my screen that it is a legal entitlement. This is the right. So a right is a legal entitlement to have or to do something. It's a privilege given to all citizens. So I have the right to life. I have the right to religion. I have, and these rights are protected by law. So I must know that these are my legal entitlements. Now, we have freedoms as well, and we will cover that later, but it's important to know what freedoms are. And freedom is the quality or the state of being free, and also it is the absence of necessity, coercion, or constraints in choice or action. Freedom is really an option to perform. I may have the freedom, I may decide I would like to express my freedom of speech, or exercise that freedom. I might like to write on Facebook about my views about what the government is doing correctly, or I think that the government is not doing correctly. Or for that matter, if I was in the universities, what I thought the various policies or the lecturers put in place. So that's the difference between a right and a freedom. One is an entitlement, which is protected by law, and the other one is an option, but it is definitely a quality or state of being free. Now, looking at the list of rights that we already have, and there's numerous rights that are there, and some are more affected than others when we have a pandemic with the different laws. But just for the knowledge of everyone that's on this forum, you've got the right to life. And this is the guaranteed right. Nobody can take this right away from you. That's why we don't have those barbaric laws of hanging that we used to have in the past, because this is an absolute right. You have the right to personal liberty, and we will discuss that further later on. You've got the rights of arrested and detained persons. I mean, the right to personal liberty, we know from COVID-19 laws, people are, you've got the restriction on social gatherings, on a the rights of arrested and detained persons. Obviously, those that are breaching the, sorry. Can you all hear me?
Yes, we can.
Okay,
yes.
Great.
Right.
So the rights of arrested or detained persons. Now with the curfews in place, we have many people that have been arrested and have been detained by the police, and you have the rights of accused persons, because when you're arrested, you obviously are taken through an interview, and some are charged, some are not, but there's accused persons that are also affected by this. You've got the right to access to courts or tribunals. So even as arrested persons, you should be able to be taken within time after your arrests and after the curfews have lifted, to be taken to court. You're right, you have that right to access tribunals. They cannot just keep you forever and a day, lock away the keys, one of those barbaric views. You've got the right to employment relations, and you see that under Section 20. Obviously, this right has come up much since yesterday, much discussion on this right, because under this right, you got every person has the right to fair employment practices, including humane treatment and proper working conditions. Many lawyers that I've talked to had, numerous phone calls from their different friends at Fiji Airways, those that were terminated, whether their right to fair employment practices was breached. And that's a buzz of a conversation that's happening right now within private practice as well. You've got political rights, obviously, to political views and parties. You've got the right to privacy under Section 24. And you've got the right to equality and freedom from discrimination. Sorry about that spelling. You've got the rights of ownership and with regards to your lands. And you've got the right to landowners' royalties. And you've got the right to education, which obviously under COVID, we've had the closure of schools. Students are at home, much to the joy of some parents and much to, not too much to some, I'm sure. Now, you've also got the right to economic participation. Obviously, under Section 32, you'll see that under that right, let me just read it out for us. Sorry, give me the chance here. Under Section 32, we have every person has the right to full and free participation in the economic life of the state, which includes the right to choose their own work, trade, occupation, profession, and other means of livelihood. That has been somewhat affected with all the restrictions. You can't go to your shops and open up. You can't, and at that time of the lockdowns. You also have the right to work and just minimum wage. Obviously, that has been affected for many people as well, those who have lost work because of the COVID pandemic. Right to reasonable access to transportation. Obviously, because of COVID, transportations were affected because of curfews. There was only certain times they ran the public transport. You've got rights to housing and sanitation, and of course, with the pandemic issues, We've got lots of people that have lost jobs, they can't pay the rent. You know, landlords and tenants have had to negotiate, and some people have actually lost their housing because they don't have enough funds to pay for their rentals. Right to adequate food and water. You've got right to social security schemes, right to health. And I mean, this right to health is what government has used under the Public Health Act to ensure that they perform their duty in protecting the public. You've got environmental rights, obviously rights of children and rights of persons with disabilities. And those are the rights that you'll find in the Constitution. And I've just touched generally on the different rights that the COVID-19 has affected. Now, we also have, and remember all the rights that I've mentioned, these are guaranteed rights, these are supreme laws in our Constitution entrenched. Now, you also have freedoms, and you'll see from the different freedoms that I've listed there, not all have been affected by COVID, but obviously you've got freedom from cruel and degrading treatment, which is Section 11. That's the section that was a point that was raised by Judge Temo in his judgment with regards to the unfairness of the sentencing approach under Section 11.1. And so freedom from cruel and degrading treatment, even though I put it down as Section 11, Section 11 specifically says that every person has the right to freedom from torture of any kind, whether physical, mental, or emotional, and from cruel, inhumane, degrading, or disproportionately severe treatment or punishment. And it's the disproportionate, severe punishment or treatment or punishment, which was what Judge Temo used in his judgment that he used as a justification to basically review the magistrates' court's different sentencing that they had done for COVID-19 people that were in breach of the curfews or the Public Order Act. Now, we look at the next one, which is reasonable search and seizure. That's also freedom of speech, expression, and publication. Under Section 17, we've seen where we've had a write-up by the military Brigadier General Chone Kaloniwai on the justification of curtailing the freedom of speech and freedom of the press based on the COVID-19 situation. And of course, that obviously goes, I mean, that actually is a opinion that justifies why that freedom should be limited. You've got freedom of assembly, obviously the different churches and religious groups, and obviously different organizations that couldn't have an assembly. And, you know, in Fiji, we're the Pacific, we're so accustomed to gatherings and meetings. So freedom of assembly, I think, was quite a challenge as well. Freedom of association, obviously affected by COVID-19. Freedom of movement and residence. Clearly that also was affected because our movements were limited. Freedom of religion, conscience, and belief. I mean, that, although that's a freedom, that I don't think that was it wasn't affected because it was just the assembly and the association as opposed to the beliefs system that we had. And obviously we had freedom of compulsory arbitrary acquisition that wasn't affected, protection of ownership and interest in land, as well as the freedom from arbitrary evictions. Now, we have cases of those that have been evicted. Now, before I go into after you see the different rights, the different freedoms that are there in our Constitution, which the legislature, judiciary, and executive are, it is mandatory for them to apply, and the Constitution is very clear about it. We also have to be mindful that this Constitution also has its limitations. But for now, the slide that we have talks about the application of the Bill of Rights, and it's reinforcing the fact that the government or those performing functions of public office, they must recognize the rights and freedoms, because it says, you see, section 6, subsection 2 says, must respect, promote, protect, promote, fulfill the rights and freedoms recognized in this chapter. And so it's mandatory. It's not an option. It says must respect, must protect, must promote, and fulfill. And so you'll see that basically in section 6.1, the Constitution has put in mandatory provisions recognizing these freedoms and rights and the application of it. And I've basically quoted from section 6 subsections, all the different subsections. And the other thing that must be recognized is, apart from the fact that it's recognized, it also states that there are restrictions in this Constitution. And you'll see it says that the rights and freedoms set out in this chapter apply according to their tenor and may be limited. So there's a discretion there, may be limited by authorized or permitted under law, right? So limitations expressly prescribed. So it has to be written, it has to be prescribed and authorized or permitted in this Constitution. It must be expressly. So in essence, what it's saying is that there must be proper, if it's not in this Constitution, then there must be proper laws legislated by Parliament or proper laws put into place that justifies or that specifies the limitations. Now, apart from that, you also will see that there's also, that's with regards to rights and freedoms, subsection 5, but you also have to appreciate that under the limitations of freedoms, there are specific sections under that, and I've just put them out. I've just listed them so that you can see the common thread of these limitations of freedom. So, for example, under section 17, subsection 3, you know, section 17, if we look at section 17, this is the right for the freedom of speech, expression, and publication. And of course, we know that one of the political figures, Linda Tambuya, was alleged to have made a statement or expressed her view on her Facebook page. That matter is still in court. We won't discuss the merits of it or otherwise, but section 17.3 was, I think, caused that particular issue caused a lot of discussions amongst the public as well as the legal fraternity on it. But section 73 does have a limit, and it says to the extent that is necessary. So one, you've got the limitation that it must be necessary. A law may limit. So the law must limit. There must be a prescribed law by Parliament limiting or may authorize the limitation of the rights and freedoms mentioned under subsection 1. And section 17 obviously says every person has the right to freedom of speech, expression, thought, opinion, and publication. So I have the right to my opinion, I have the right to publication, but in this one, it says that that right can be limited, and here's the requirements, in the interest of national security. So if my opinion is going to cause an issue of national security, that's where they say the Constitution says is justified, public safety, public order, public morality, public health, or the orderly conduct of elections. Now you look at the second limb, the protection or maintenance of the reputation, privacy, dignity, rights, or freedoms of other persons, including the right to be free from hate speech. So if it's hate speech, whether directed against individuals or groups, and the rights of persons injured by inaccurate or offensive media reports, to have a correction published on reasonable conditions established by law. So you'll see that that's 17.3. Now, there's other requirements, and if you do have the time to go under section 17.3, you'll see that it's got A, B, C, D, E, F, G, H. basically giving you a justification of what the limitations of the freedom of speech is. And you'll see it says in here, B1.2, the protection or maintenance and, to protect dignity rights. And it also goes against preventing the disclosure of information received in confidence, preventing attacks on dignity of individuals and groups. In some ways, it's starting to go, it looks quite general, the dignity of individuals or groups of individuals or respected officers or institutions. I mean, it's wide ranging in its coverage. DEF, maintaining the authority and independence of the courts. So you can see the importance where if your freedom of speech or publication affects the authority and independence of the court, it imposes restrictions on the holders of public offices, regulating the technical administration of telecommunications, making provisions for the enforcement of media standards, and providing for the registration and conduct of media organizations. So here are the different restrictions, but it must be by law. Now, if we look at 18.2, section 18.2, you'll see that section 18 is about freedom of assembly. But when you look at it, it also limits, or it authorized the limitation. And again, you see, there's a common thread: national security, public safety and order, morality, public health, protection of the rights and freedoms of others. So if your freedom of assembly, if I'm going to get together and I've got, COVID-19 and I'm going to affect somebody, infect somebody else, then obviously you'll be affecting somebody else's right to good health and their life. Now, and I'm putting this because I'm placing this on this slide because even when you look at section 19.2, that was freedom of assembly earlier at 18.1, freedom of association in 19.2. You see the famous, the common thread there is, you can see national security, public safety, public order, public morality, public health, and then it does expand it. And that is the same for 25. And you'll see that 25 is with regards to employment relations. And again, you see that it is justified. The law may limit or authorize if it's in the interest of national security, public health. The same one, same for 21.7. And these are the ones that are basically right now causing much, it's the one mainly affected by COVID-19, the freedom of movement and residence. Again, it can be justified, the law, there's a limit where if the law authorizes in the interest of national health, national security. Now, having said all that's the limitations of the different freedoms and rights that we put in place. But section 43 is with regards to states of emergency. And you'll see again that section 43.1, any law enacted or promulgated in consequence of a declaration of a state of emergency. Granted, we don't have a state of emergency, but we have the Constitution addresses that limitation of rights under states of emergency, and in it, it's very specific that the rights and freedoms under section 8 and 10, and section 8 is right to life. So state of emergency, right to personal liberty. This is another justification of the states of or restrictions under the Constitution if there's a state of emergency. Now, sorry, putting that aside, what we have now after that, you've got the Constitution, you've got your limitations and restrictions. You also have the COVID cases, the COVID laws, as I call them, the COVID laws that were put in place to ensure that, that the public was protected. And for that, let me just pull that up. Sorry, if I could just, so how do I do that? Sorry, just give me 2 minutes while I try and pull that up. Are they even looking at this? Sorry if you've had to look at my emails. I'm trying to find that slide. Now, this is the extract. To put it case in point, what I've done is I've just referred to the extract in Judge Temo's decision. And the only reason I've done that because I believe it sets it out properly, and I could have just cut and pasted. But for our benefit, you'll see that in it, it talks about how the state is duty bound, to ensure that we have laws in place during this pandemic. So you've got the Public Health Act and Section 69, 60, 69, 1 and 3, that ensures that for the prevention of it and the checking of the spread of this infectious disease, the minister, and the minister here being the health minister, and the permanent secretary that has these powers to prohibit, order, and regulate. So they have the powers, the minister of health, not the prime minister, the minister of health, not the minister, not the other ministers, very specifically, the minister of health and his permanent secretary have the powers to do this. And so we have the minister and the permanent secretary that have, under Public Health Act, that have put forward orders. Thereafter, we had the social gathering law under the Public Health Act, which obviously, if you look at the slide, the social gathering law, which basically prohibited all the different gatherings of assembly, religious gatherings, and so basically affecting the freedoms and the rights that we have under the Constitution. So this is in fact in line with what the Constitution says, that there must be a specific order that, or a specific law that restricts those rights and freedoms. And so obviously with regards to gathering, this was the specific law that prohibited social gathering under Notice 2 of the Public Health Act. Thereafter, we had curfew laws. So apart from social gatherings, the government put into place, rightfully, curfew laws to ensure, to stop the spread of COVID-19 so that people could, within certain time periods, be at home. So apart from social gatherings, we had another law that said, from 10 p.m. until 5 a.m., the whole of Fiji, had to be on lockdown. And these notices, they were gazetted, published, and that was the law in place. Of course, you can see from the third one, the social gathering and curfew laws under public notice number 10, what it did was, except for a gathering of less than 20 people. So we had the social gathering that was restricted, then we had the curfews, and then because, government has to rightfully just, balance between the economy. I mean, you still need taxes paid, you still need to fund the economy. So you still needed employment for people because lots of people were not working, and a lot of people were on pay cuts for those that had also stayed home or working from home. So there had to be a law in place to ensure that the economy was working. So we've got the public notice number 10. So people started going to work, 20 people in the course of employment, and that was lifted. Now, after this public notice number 10, I mean, along the way, there were still people that were breaching social gathering. There were still people breaching curfew cases. And of course, the court then passed an amendment. The parliament, there was another state passed the Public Health Amendment Act, in which they increased the fine from $20 to $40 to the $10,000. And this obviously became the subject of the cases that have been in court with Judge Temo and the review by our acting Chief Justice. But these were the laws that were put, the framework, the laws or the framework of laws that were our guidance with regards to the laws in place, COVID laws, and limitations. So I just thought I'd give you a framework of that. Can anyone hear me? Yilish?
Yes, we can hear you all right.
Yes. So right now, that's from what I was first asked to do. I'm just giving a framework of the different laws that were there and the different rights. So I will stop there for now.
Okay, thank you very much, Laurel, for that very insightful presentation. And I hope that had a lot of information, and hopefully that is going to also lead to some very good discussions on what ought to be the kind of laws, regulations that need to apply. Because, as I've said earlier on, there's a very strong imperative for some restrictions on the constitutional laws or constitutional provisions relating to rights that are there. However, we need to keep agitating to ensure that these restraints are reasonable and that we don't have overly draconian uh, imposition of laws by the law enforcement agencies. So we're going to open this up for questions and answers. So all participants that are joining us, now is the time if you have any questions. I know that there's a lot of confusion amongst the populace. A lot of people do not really understand, what is the ambit of those rights, and some of the laws that have come into application. The state of natural disaster that was declared on 15th April, and then subsequently the there was a specific law that was also made by Parliament following the COVID-19 response budget, which also gives quite wide-ranging powers to the Permanent Secretary for Health and the Minister to be making certain pronouncements and laws um, during the course of the pandemic. So we'll now open it up to the participants for questions. I'd also like to acknowledge the participation of Mr. Adiaman, who is from International IDEA, and he is the overall project manager of the Fiji C3 project, and he's also with us for this meeting. So Adi, welcome to the meeting, and we hope to hear some good, profound contributions also from you, given that you're also a lawyer, and you definitely have a lot of expertise in matters relating to this, and generally your experience with human rights, with democracy, and generally with the promotion of this in a number of contexts. So let's open it up for questions. I mean, we have opened it up for questions, so let's get the questions. I'm sure that there's a lot of people that do have questions, but perhaps camera shy at the moment. But this is an opportunity for you, whilst we have Laurel with us, because she also has other commitments, so won't be able to stay for too long. So this is the opportunity for any questions that you would have for her at this stage.
Hello, Gula Vinaka Nilesh. Adi here.
Yeah, Bula Vinaka Adi, how are you doing this morning?
I'm good. I'm good. Thank you. I hope everybody is doing well as well and staying safe. Thank you for welcoming me. Sorry I joined a bit late. I joined in the middle of Laurel's presentation today. If I may, let me kickstart with a question to Laurel. So despite of the limitations and restrictions, is it then justified what the government has done in the guise of promoting health or maintaining health rather in the community? Thank you.
I think what we go back to is what the Constitution gives us, and the right to health, and the right to life. And the reason that prior to COVID, we have the Public Health Act is really for the protection of the public and to ensure that, fast forward, even when we come across pandemics such as this, the laws that are put into place are there for the protection of the people. So it is justified because it is their duty. They have to ensure that the public is protected. And so the laws with regards to keeping people, restrictions of movement, and I'm referring specifically to the restrictions of movement and the curfews and the social gatherings. These laws are critical. It's not an optional type of law when you have a pandemic, because worldwide people are dying, and it's sad. I mean, even now, someone was just telling me recently, and I stand to be corrected, but then America is now surpassed 1 million. And the different countries where there are just thousands and thousands of people dying. And in Fiji, where we have less than 1 million. And the truth is our health services are not in the level of those countries. We are looking for aid for health, for all the health equipment that we will need if it went to a stage where people were dying. And so it is important, and I believe the government is justified in putting the restrictions they have, the social gathering restrictions, the public health restrictions. And you've got also, you didn't mention a specific law, but you've got the law with regards to increasing the penalties from $20 to $40 to a higher amount. And I believe the government is justified in that respect. At the end of the day, it's the application of the law by the tribunals, by the courts, that have to be considerate of the values that the Constitution puts into place. But to answer your question, the answer would be yes from me, given my long explanation as well.
Vinaka, Laurel.
Laurel, it's very interesting if you look at the Constitution, particularly if you look at Chapter 9, which is on emergency powers. This is quite a big crisis that we're going through. But it is very interesting that the government has still not invoked its emergency powers under Chapter 9 of the Constitution. And as you mentioned, the Constitution is, of course, the sovereign law of the country. But the government has actually chosen to use subsidiary to use laws that are at a lower level, subservient to the Constitution, to be, and using these to be generally for COVID-19 containment, as you've talked about. So do you find that interesting? Or maybe, because if you look at Chapter 9 of the Constitution, one of the conditions for invoking or the process for invoking emergency powers under this particular constitutional section is that the parliament has to endorse it. It is the parliament that would need to approve the proposal by the executive arm to invoke emergency powers under Chapter 9 of the Constitution. So do you think that it is a little bit interesting in that context that that particular provision has not been used. And then we have a new legislation, which is, I think, the public law. Not, I mean, there's an amendment of an existing law, which is Public Health Act, which was amended. But we do have another constitutional provision right there, which is declaring a state of emergency.
Yes, I mean, initially I thought they would have invoked the emergency powers, which is what was done in many other countries across the globe for this to address the pandemic. And obviously they have their reasons. And when you look at the state of emergency, there's two requirements before the Prime Minister may. And one of them is that the police commissioner must recommend, and the commander of the Republic of the Fiji military forces, they must recommend to the Prime Minister that there be a declaration of state of emergency. And obviously on the reasonable grounds, the security and safety of all or part of Fiji is threatened. And it is necessary to declare a state of emergency to deal effectively with the threatening circumstances. And when you look at those requirements that are in place, I'm not in the security forces or in the discipline forces to be, as to the reasons why they did not invoke this. And all I can say is that with the different laws, they've had to put new laws on the ground with regards to the public notices. They probably thought that was sufficient. At the end of the day, the call is the Attorney General's with regards to whether we have sufficient laws in place to protect us. And that's the reason why they used the Public Health Act and put through those different public notices. But one would think that would be the first move. It would be to invoke the emergency powers, and I mean, unless the police as well as the military commanders didn't think that we were under some threat, or part of most of Fiji, that's the reason why, because there are two limbs that they have to satisfy. Also, the other issue that I thought was interesting was that we had invoked the natural disaster legislation as opposed to the emergency powers. So, ultimately it's government's call, but it may be something that the Attorney General's office may consider putting in new laws, like in New Zealand and other countries where they have laws already in place, which addresses pandemics and epidemics, so that when such an event does occur, they're able to just fall back to the laws that they've already drafted. And everything is a learning curve, and if anything, for me, it shows that we obviously need to legislate new laws to be able to address all the different vicissitudes of life. You can't think of all of them, but because history has shown that pandemics have been in place, under the Public Health Act. We did find it strange that the emergency powers wasn't invoked, but like I said, there are requirements to it, and obviously the two main military, the military and the police, did not see that there was a security or safety or threat. Alternatively, they were persuaded that we had sufficient laws, or were able to, sufficient laws, or we were able to just have public notices under the Public Health Act to be able to protect our citizens.
Yes, definitely. Very interesting indeed, because one would think that, any law that is actually passed by Parliament would be a bit more legitimate in the sense, rather than the executive arm of government unilaterally invoking those particular provisions of the Constitution. So let's hear from the people, from the participants, questions and even comments that you have at this stage that you'd like to put forward. Let's hear from some of the participants too. Yes, Rajan.
Hi, Laura. Hi, Nilesh.
Hello, Rajan. How are you doing?
Good, good. I just got one question for Laurel. Not a question, like sort of like an advice. What advice would you give to the people in terms of exercising their rights in this pandemic? What should be what the people should be careful with? What they should do and what they shouldn't do, sort of.
Thank you. I think what it was that earlier on with regards to the different limitations that you have already in place under the Constitution that I covered. You'd see that if you believe that for example, let's go into it. For example, freedom of expression. We do know of certain, Linda was arrested because of what they say was, what she had published on her, or alleged to have published on her Facebook page. So really today we have lots of people that are placing or putting up their opinions and views, and they, whether the question is, can I just say whatever I want to say? And I think the other question you have to ask yourself is, are there any restrictions at this time that are applicable to what I'm saying? Does it go against national security? Does it go against public order? All those different restrictions that I'd mentioned. And that's on the one hand. And on the other hand, there is I believe it was the former Chief Justice, Anthony Gates, when he was making his presentation to Parliament on the freedom of expression, one of the things that he said under this freedom is that, and I just wanted to quote it, and I thought it was quite relevant. He said that, we don't have to like what we have to hear, but we must keep listening. And he says, I'm unable to rationalize why are we trying to bridle the discussion on matters of national interest. Now that we are all Fijians, make more the reason for us to freely express and share our views on issues that affect our lives. I firmly believe that engaging in such conversation is healthy for inspiring a sense of patriotism amongst our people. And this was with regards to the restriction imposed on public gatherings to discuss national issues at that time. But, linking it to our discussions today, you do appreciate the restrictions that are there under the Constitution, but at the same time, there has to be a balance where your opinion or your ability to express, it's not boiled down with fear. You're frightened to say something because you're thinking, I might get arrested. And so that's where the reconciliation of your rights, the limitations, as well as being able to have a point to discuss on something that is of national interest. And so that's my, I thought I just quote that because I thought that was quite relevant to us with regards to expressing or talking about national interest issues. But if for the general, your question seems to be a very general one because there's so many rights that have been affected. And I think if you believe that what you're going to put up may breach the Constitution, might be a good idea to get some legal advice on it before you place it on record. For example, if you're going to put something up that criticizes a judicial officer, then you must ensure that it's not one that affects the independence of the judiciary. So if it's something that's going to be in breach of the Constitution, then please, by all means, and if you're not sure, there's always legal aid there. There's always the Law Society. We do have different members of public that come to us, and we find different ways that do it for them pro bono.
Okay, thank you very much for Lauren for that response. I know that there's a lot of confusion, and if you look at how the courts, different courts have also interpreted some of this legislation, then you will understand why there appears to be quite a high degree of confusion. And very interesting point that you mentioned. um, and I think recently there has been quite a lot of discussion also on the ox test. And interestingly, we don't really have jurisprudence in Fiji relating to that. That has never been put to judicial review, and that has never really been applied in Fiji's context in recent times. And that is why it is very important that in the absence of judicial review, we create platforms of this nature where people do get to dialogue on what really do constitute reasonable limitations on constitutional rights. And especially from our perspective as human rights defenders, we need to continue to always ensure that the limitations are proportionate, that they do not disproportionately and unreasonably limit rights and freedoms of people, especially when there's a national interest involved as well. And I think everybody agrees that the COVID-19 pandemic is unprecedented in many respects. I don't think in Fiji's modern history is of this nature, which has dragged on for so long. Of course, we have had many typhoons and hurricanes and so forth, and we've also had political upheavals, but most of them were contained within a short period of time, and then people went back to normalcy. But COVID-19 threatens to upset the balance and the stability that had been created, the normalcy that people now in a number of ways. And that is why it is a novel situation, and it is presenting many complications, not just for the law enforcement agencies, also for the judiciary and the lawmakers as well. And which is why it is absolutely critical that there is discussion and a wide range of views are taken into context to see how best to deal with a novel and complex situation like the context that has arisen because of the COVID-19 outbreak in Fiji. And we hope that there would be more discussions happening, and a whole range of views are going to take into context. That be taken into consideration. We all agree that the government is justified, perhaps, and they are correct in ensuring the safety of every Fijian, and and all efforts to contain the virus need to be supported by every right-thinking member of our society, by every upstanding citizen of Fiji, and we certainly don't dispute that. But what we're saying that any excesses by the law enforcement agencies, by lawmakers, by law enforcement agencies, they need to be sort of controlled or reduced. And that's why it is always important to for a group of people to continue to agitate for some of these things. Otherwise, we will end up with a more restrictive context, and then people are going to have even less avenues to be able to talk about issues, about things that shape their lives. Right? But to every participant that is joining us this morning, we're giving you this opportunity right now to have your input, to have your say. You shouldn't be intimidated by the nature of the discussion, which so far has been fairly technical, I know. So every question is an important question. Any question that you might have, please, this is the time for you to be able to put them forward. Any comment that you want to make, this is the opportunity. Those, your questions do not necessarily need to be too technical or too, they don't need to be really on technical aspects of the law and its applications, but it can be just anything that you feel is relevant when it comes to your constitutional rights or generally your democratic rights and freedoms, and how they should apply during states of emergencies. Yes, Laurel.
Right, issues. Now, under the ICCPR, which is the International Convention on International Covenant on Civil and Political Rights, wherever there is a restriction, wherever there's a state of emergency that is declared. For example, Article 4 of that covenant prescribes that there'll be no derogation from the following articles of the covenant, and this is like, therefore you cannot justify derogating from it. So one of them is obviously the right to life, but there's also Article 7, which is our equivalent of our 11 with respect to the degrading, punishments. And you'll see that you cannot derogate from that. You cannot derogate from freedom of thought, conscience, religion. And so, whether that was also one of the reasons that that it wasn't declared a state of emergency, because we are under that covenant, if it's a state of emergency, but then you still can't derogate from those rights. I'm not saying that that's one of the reasons. What I'm saying is that it is a possible reason as well, as one of the laws that, international laws that we, Fiji, recognize.
Mm-hmm. That's right. But of course, you'll agree that it is very not that simple to get redress under the international law mechanism that is there. Anyways, we have a question or a comment from Marida.
Yes.
Marida.
Morning, ma'am. My question is, what would be your advice to us citizens? Perhaps a good example was the case in Taleb, whereby the young man was thrown to under the bridge by the police. So how we as citizens, being intimidated with those kind of activities, seek legal advice, or who do we go and see to report these kind of issues? Because the very authorities that are supposed to be protecting us are abusing us. Naka.
Okay. That is a valid question, because those concerns, they're not new. Police brutality is not something that just happened. With respect to that case, because it is in court, I will not comment on it, but I will comment on the fact that police brutality has been there in the past, and citizens do look to the police for protection, and there are times that you have the rogue polices, as the Prime Minister has called them, and I'll give a personal example. We have a case currently where we're dealing with allegations of police brutality against one of our clients, and we have to follow the due process, and it means we've had to write to the standards committee under the police. We've had to write to the DPP's office. We've written to the police commissioner, and this is most recent, all this correspondence that we put in place, because it was the police officer who had inflicted great injury to our client, and we were instructed. We've got photographs, but who do we go to? We still go back to the police, because there are rogue officers. I do agree, there are definitely rogue officers in there that we've come across over the years, but there are also some good officers that are there that are working hard to uphold the rule of law. And it's, it will not be fair to taint a few of them with the total brush, although sometimes the injury is such that you can't understand why they would not do their duty, why they would not attend to their duties, but do the exact opposite of protection. So my advice is still go to the police. but it'd be good to have a lawyer with you. And it's important that you take, I mean, legal aid is free, it's a free service for those who qualify. And, if you're not certain about the further steps to doing it, please seek legal advice, because even for the matters that we have dealt with in the past, even as lawyers, we've also come across barriers. When you're writing to them, you also have rogue officers that are friends of these police officers, where the file has gone missing, where the medical has gone missing. I mean, this is the truth of the situation. But also, I have had police officers who have been most helpful, who have directed us to the right place, who have given us, the due process of being heard. And we've also had cases where the police officers have been charged themselves. So basically, yes, have faith in the system, although there are some parts of the system that are not operating perfectly. But you will need to voice it out. Otherwise, it'll be just something we discuss in our communities, but not take it up. And it must be taken up, because the system must be tested. The system must be proven to be true.
All right. So Josevata had a question, I believe, or comment to make. Josevata, you have the floor.
Oh, cool. Yes, I apologize. I had a question for Miss Laurel Varesi. My question was based on would it be wise state upon a court hearing in terms of breaching the curfew? Because most of the cases, I mean, I do counseling sessions for my clients, and most of the cases are youth. And this is one of the questions that normally comes out in terms of they're worried about getting a police record. But in terms, would it be efficient for them to write a letter to the state in regards to their particular case? I don't know if that makes sense.
You're going to court, your client obviously has charges that the state must prove. If you're going to write an apology letter, then clearly you're admitting to the charges, or at least some of the charges. And so it does present a double-edged sword, in the sense that, one, you could be just getting your client into more trouble because the apology letter is a confirmation. But if you are concerned about the conviction, which I found that many people are concerned about, they don't want this conviction on their record because it does affect you getting a visa to different countries, then you obviously either have to go through the trial. But I must say that there have been cases where, we've had to talk it through with the officer before the charge, because after the charge it's different. Before the charge, there may be some reasonings and misunderstandings of the different evidence or investigations. But I would not advise with regards to writing an apology letter, and unless you've finished, your client's been convicted, and that is a mitigation of sentencing. But if you're writing it and you're putting it on record, it can be used against your client.
Thank you for that. I think it makes sense a lot.
Okay, so any more questions or comments that other participants have? Alanita, I believe you have something to say?
Hi, good morning. Can you hear me?
Yes, we can hear you, Laura.
Yeah, Laurel, I just have a question. When you mentioned earlier about Chapter 17 on freedom of speech, expression, and publication, I was just quickly reading through it, and with young people, we have this this word that when we freely express ourselves, especially on social media, young people are confused with this phrase hate speech. Like, They use it when it's usually when they feel offended by what is posted up or what is said on social media. They use that word hate speech. Like they say it as if, I mean, like for me, I get confused when people say hate speech. Like to what extent of what or how we freely express ourselves, to what extent can we say that that is hate speech? Because right now young people are just throwing that word out there just when they feel offended or when it's an offensive post, and they just throw that word out there. So can you just clarify to us young people on to what extent can our freedom of expression become a hate speech?
Um, sorry. Under the Constitution, under Section 17, subsection 4, it says hate speech means an expression in whatever form that encourages or has the effect of encouraging discrimination on a ground listed or prescribed under Section 26. So in essence, if you look at Section 17, subsection 4, it's very clear that the effect of it must not be one that encourages discrimination or one that is listed under subsection 26. And I don't, I'm sure that when you are writing something or you're expressing something, if your comment will be the effect of it, will cause someone to say, well, I don't like that guy because he dresses weird. I think he's gay. Or, have a corresponding effect of discriminating with regards to race, or with regards to ethnicity, or with regards to, and you look at Section 26, and what it actually brings out. Let me just go to Section 26 so that, I cover it correctly, and I'm not just talking about discrimination without attaching it to what discrimination means. So under Section 26, it says, it's the right, equality, and freedom from discrimination. So every person is equal before the law and has the right to equal protection, treatment, and benefit of the law. And it talks about equality and freedom from discrimination. So under Section 26, so you cannot be unfairly discriminated based on race. So whatever your comment is, if it's meant to discriminate against someone because whether they those type of comments, culture, ethnic, social, color, place of origin, sex, gender, and if it's your speech will cause that effect. The word here is effect. If what I say will cause an effect with regards to discriminating that person, then that is hate speech. And if you look at it, it says opinions or belief, it says economic or social or health status, disability, race, religion. So it's so important that as young people, we don't want to hamper their freedom of expression, not just young people, anyone for that matter. But if your comments will cause an effect of discriminating someone because of their origins or their color, it should actually raise red alert signs or alarm bells that, it will cause someone to think of someone even less in discriminating them. And I think it leads to the other point, and that is we probably need more awareness on the ground, more public workshops on the ground that give a proper definition, because it's one thing for me to just answer questions, but it's another one to just be concentrated. And I'm glad you raised this, because it may be something that this forum may take on, Dialogue Fiji, whether they have proper work on the ground about freedom of expression and the exceptions on or the limitations with regards to the restrictions with regards to hate speech, because a lot of times young people need to hear, or anyone for that matter, what is the examples? What examples? Because sometimes I may be writing and in the in my zeal and my passion for the topic, I may not be aware or alert to the fact that this is actually hate speech. And sometimes, even as lawyers, we ourselves have had to reconsider our writings or the way we have put a point across in court so that we are in compliance with the law. So I would say that the Constitution is quite clear, but we do need workshops where proper examples and proper cases from different jurisdictions about what the examples of hate speech is, so that people have a good guidance on it. Finish. Thanks for joining. I'm sure everybody's still recording and I'm saying finished, but I hope I've answered you properly. Is that acceptable?
Yes, thank you so much.
Okay, thank you very much, Alanita, for that question there. Anybody else has anything else to say, Ed? Okay, Noel, you have the floor now.
Thank you. It's just a thank you to Alanieta for specifically pointing out young people with regard to hate speech, because discrimination based on age group, as we all know, doesn't exist. That's all.
Sorry, I didn't quite get that. Sorry, Noel.
Noel, would you be able
Sorry,
to
my speech, my computer, my connection did something about doesn't exist. I didn't quite get the one before that, Noel.
It was a thank you to Alanieta for specifically pointing out young people with regard to hate speech, because as we all know, discrimination based on age group does not exist.
Okay, and I suppose as a young person, you would have some views, Noel, on social media, the sort of interaction that happens on social media. I know that people do have an issue, a lot of people with the rampant hate speech that is commonplace on social media. But on the other hand, how do you actually strike a balance between enabling free expression and then regulating speech or hate speech on social media? Because social media is very, very difficult to regulate, and I think most jurisdictions that have sought to regulate social media have actually ended up banning the social networking platform altogether. So do you have any opinions about the sort of interaction that happens on social media, and what and since you do seem to have an opinion on hate speech?
In 2016, the US presidential election was rigged by a company called Cambridge Analytica that used Facebook data sold by the company itself. That company also rigged the Brexit election, according to various reports. So if social media can be rigged to such an extent and 4 years later, Facebook still can't fix their issues, I don't think I can.
Okay, all right. Yeah, it is a very difficult question, and I think it is a dilemma of sorts as well. How do you strike the right balance? But I think people do realize that social media can be a powerful tool for communication. It has become an important part of people's lives. So that's why there's suggestions that perhaps we might just have to leave with hate speech, and then perhaps the best solution lies in educating people on how to validate information on social media, be able to discern valid information from fake news and other misinformation that is peddled by different interests on social media networking sites. So I don't see any hands up at this point in time. So I think we will be rounding off this session. I'd like to thank very sincerely Ms. Laurel Vorasi, the president of the Fiji Law Society, The Fiji Law Society has always been very cooperative with us. They have always responded very positively to any request that we have had in the past, and we're very proud of the partnership that we have cultivated over the years with the Fiji Law Society. I think it is absolutely important that human rights, civil society organizations, or human rights NGOs need to have a very strong relationship and partnership with the bodies like the Fiji Law Society, because there are um, linkages in the type of work we do, and there are of course similar interests that we are pursuing when it comes to the protection of rule of law, when it comes to the upholding of human rights and other civic liberties. So thank you very much, Laurel, for your time, for your effort into preparing and making the presentation. I know that uh, um, you have a number of other commitments, you have a busy schedule to attend to, but you um, agreed with our request and were able to join us, and you made a very insightful, very informative presentation, and you were able to respond very well to the different questions and comments that our participants had. So once again, thank you very much, Laurel, for your participation.
Thank you very much, Nilesh, and thank you, everyone. I would like to thank you for the time and this opportunity to actually discuss these issues. I've had other forums that have asked, but somehow I believe Dialogue Fiji is the forum that I believe we need to work more together and have more people discussing these hard questions as well, and issues that are of great public interest. So thank you, everyone, and we'll talk again soon. And Nilesh, I'm sure we should have that outstanding coffee after all this time. Thank you.
Definitely, we need to. All right, thank you very much, Laurel, once again. And that brings us to the end of this webinar. But before we go, if there's anybody else with any final comment, or if you have any general observations about the webinar, especially those that had been with us from yesterday. If you also have any feedback, you can make them now, or otherwise you could email or send us a message on different platforms that we have, and we will definitely appreciate that feedback. In fact, this is the first time that we have tried a webinar of this nature. We're more accustomed to face-to-face interaction, so we were a little bit awkward as well. And I think, participants too were not too comfortable, but eventually we saw more people opening up. But I think this might become a norm of sorts going forward, given the new the developments that we have had with the pandemic. And I think this remains a very cost-effective way of also reaching a good number of people. So we do have other webinars and other events of this nature which would be delivered through online mechanisms that we would be conducting in future, and we're going to be, of course, keeping you in the loop. We'll be sending out notifications of that through email and other communication mediums. So thank you very much. Adi, would you do you have anything else to add before we round off this webinar?
Yeah, Binakavakalevu Nilesh for the time. And thank you, Laurel, once again for your insightful presentation. And I hope all participants believe that this is something. This has been something useful, as Nilesh said. It's quite new, but I've participated in these webinars in other contexts too. And it does take some time to get used to, but it can be very interactive too. Especially maybe if if we have more participants in the room, maybe it'll become livelier, and there might be more thoughts and perspectives being brought forward in the webinar. But I agree with Nilesh that this may be something that will stay on in the future, and hope everybody will come back to the next one. Thank you once again, and hope you have a great day.
Thank you very much, Adi, and also to International IDEA, who are our lead implementing organization in this project. Thank you so much for your technical advice, your assistance, and your continued support over the years that you have provided. International IDEA, of course, is a very prominent intergovernmental organization, very prolific in terms of their research relating to elections, to democracy and human rights as a whole. So you can check out their website and you will see that they're a very resourceful organization indeed. When we're very privileged to have them as our partners, and we continue to look forward to their support in future, as well as we continue to strive to make a difference in the lives of Fijians and continue to uphold the voices of the underprivileged, of those that do not have the capacity, the means to be able to input into formal democratic processes. So thank you very much once again to everybody that joined us. I hope that you have found this webinar useful. From yesterday, the discussions that we had on the economy. If you'd like to get the paper that was delivered yesterday, you can send us an email to request it. We'd be glad to send you that paper. It has not been published anywhere yet, sorry, and we can make that available to you upon request. Dialogue Fiji will be very soon releasing a report on the impacts of COVID-19 pandemic and the restrictions that have been put in place by the state on businesses, on the business sector particularly, because as I said yesterday, if we are to maintain employment, if we are to maintain household incomes of people, then we need to sustain the business sector. We need to ensure that businesses stay solvent, and we need to have empirical evidence that ought to inform decision making. And that is a very interesting research that we carried out. It's a primary research survey that we did over the course of last month, and by tomorrow we hope to release that report. So if you're interested in that particular report, we'd also be able to email that to you. And there are some hard copies which you can also collect from our office. So once again, thank you very much for joining us on this inaugural webinar that we had on the impacts of COVID-19, the economic impacts, information session on COVID-19 nature of the virus and so forth. And then today on the state of constitutional rights during pandemic. So thank you very much to everybody that joined us. Thank you for your interest. Thank you for your contributions. We look forward to your continued support and participation in future events. Bula Vinaka.